In this video, I'll explain how your AI queries for a legal case are not private. And by the end of this video, you'll learn why a federal judge just decided that everything you type into ChatGPT, Claude, or any AI chatbot about your legal matter can be handed straight to the other side, and what you need to do right now to protect yourself. All right, let's dive in. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I deal with sensitive client information every single day, and what just happened in a Manhattan courtroom should concern every person who has ever asked an AI tool a question about a legal matter. Just imagine for a second, you're dealing with a lawsuit. Maybe it's a business dispute. Maybe somebody breached a contract. You sit down at your kitchen table late at night, you open up an AI chatbot, you paste in some notes your lawyer sent you, and you ask the AI to help you get organized before your next meeting with your lawyer. It feels private, right? It feels like you're just sorting your own thoughts on a computer. Actually, a federal judge just decided that you gave every word of that exchange to a third party, and now the opposing side gets to read all of it. I call this the AI transparency trap. And once you walk into it, you cannot walk back out. Let me walk you through what just happened. Earlier this year, Judge Jed Rakoff, a well-known federal judge in Manhattan, issued a ruling in a criminal case called U.S. versus Heppner. The defendant in that case was not acting recklessly. He was not trying to replace his lawyers. He had a legal team. He had already gotten privileged material from them. All he did was use an AI chatbot made by Anthropic called Claude to sort through the material and get ready for meetings with his attorneys. His legal team then took what the AI produced and folded it into their defense strategy. But here's the thing. The government wanted to see those AI chat logs, and the judge let them have it. Every prompt the defendant entered, every response the AI gave back. The prosecution got all of it. Now you're probably thinking, wait, doesn't attorney-client privilege cover that? You're right to ask, but Judge Rakoff relied on something called the third-party disclosure rule. His logic was simple. When you enter information into an AI platform, you are sending it to the company behind that platform. And because that company's privacy policy allows it to collect and potentially share your data, you had no reasonable basis to expect confidentiality. Put another way, the judge looked at a piece of software and treated it like a person that you confided in. This is what I call the personification error. He looked at a computing process, which is code running on a server, and applied rules designed for human relationships. In the opinion, he describes the chatbots as engaging in communications with the user. But software does not communicate, it processes. The difference is everything. Now here is where this case gets really troubling. Think about Google Docs for a second. Lawyers draft confidential memos in Google Docs all the time. Google's terms of services give the company broad rights to process what you store there. Google also says that it can turn over data when legally required. It sounds familiar, right? Well, the terms look almost identical to what AI companies use. But nobody, and I mean nobody, thinks that typing in a privileged memo into Google's Docs wipes out the privilege. But Judge Rakoff acknowledged this comparison in his opinion, and then he just brushed it aside. And he said, cloud computing does not automatically carry privilege protection. But that dodges the real question. Nobody was arguing that Google Docs creates privilege. The question is whether Google Docs eliminates it. He never addressed that. The only real difference between the two situations is two letters, AI. The moment a tool gets labeled as artificial intelligence, the judge applied a completely different standard. Now, if you're watching from Florida, and I know many of you are, this needs your full attention. We have our own rules around attorney-client privilege and work product protection here. Lawyers and business owners across the state use AI every single day. I see it in my own practice in Miami. Clients getting ready for international deals, reviewing contracts, organizing their case files. Florida state courts have not yet tackled this exact issue yet. But here's what keeps me up at night. Federal rulings like Heppner, they travel fast. They get read, they get cited. They show up in briefs. A case right here in the Southern District of Florida could easily follow the same reasoning tomorrow. And Florida's discovery rules are already broad. Add Heppner's logic on top of that, and every AI conversation you ever had about your legal situation, it becomes something that the other side can demand. This is not a theory. This is something that can really happen. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. All right, here's the good news. Not every court sees it the way that Rakoff did. Other federal courts have gone the opposite direction. In a 2026 case called Warner versus Gilbarco, a judge in Michigan ruled that AI chatbots are tools, not people, and refused to force a litigant to turn over AI-generated materials. That judge drew exactly the line Heppner refused to draw. And just recently, a magistrate judge in Colorado came to the same conclusion in a case called Morgan versus V2X. Her order asked a question nobody raised in Heppner. Does having a Google account mean you give up all confidentiality? She looked at the Supreme Court's reasoning in Carpenter versus United States, which is a landmark digital privacy case, and concluded that sending information through third-party platforms does not strip away your privacy protections. So right now, we have federal courts on opposite sides of this. Some say AI is a person you disclosed information to. Others say AI is a tool that you used. That split is exactly what makes this moment so risky for you. But here's the part that should really get under your skin. This ruling creates what I call the Prosecution Privilege Gap. Federal prosecutors use AI tools constantly for investigations, case prep, legal research. All of that is shielded by government privileges. The government gets to use AI without any exposure. But under this ruling, a defendant who uses the same technology to prepare a defense just created a playbook that prosecution can take. Every question asked, every draft produced, every shift in the strategy, all sitting on the platform logs, all reachable by subpoena. The government uses AI with full protection, yet you use AI at your own risk. Now think about people who cannot afford a lawyer. Pro se litigants. Here in Florida, I see it all the time. Landlord-tenant fights, small business disputes, family law matters. These are the people most likely to lean on AI for guidance. And under this ruling, every exchange they have with the chatbot is wide open for the other side to grab. The people who need the help the most get punished the most for seeking it. So what do you actually do about this? The reason why this matters right now is that the law has not settled. There is no clear rule, and in that gap between competing court decisions, what you do today determines how exposed you are tomorrow. So stop assuming your AI conversations are private. I call this the privacy illusion. Every major AI company, OpenAI, Anthropic, Google, Microsoft, has terms of service that allows some form of data processing and potential disclosure. That is the foothold a court will use to pry open your records. Talk to your attorney before you paste anything privileged into an AI tool, not after, before. And if you are in litigation or think litigation is coming, have that conversation immediately. Here in Miami, I'm having this exact talk with my clients right now. Understand that deleting your chat history may not save you. The platforms store logs on its own servers. Your delete button does not touch those servers. That information may still be recoverable through a subpoena aimed directly at the AI provider. And pay attention to how courts in your area handle this going forward. Heppner is one trial court opinion out of Manhattan. It does not bind any other court, but it got a lot of attention. And in the legal world, the opinion that gets noticed is the opinion that gets copied. Until an appeals court or the Supreme Court steps in, the ground underneath you is moving. The deeper lesson here goes well beyond AI. Follow the logic all the way out. If typing into an AI tool counts as disclosure to a third party, then every privileged document you have ever drafted in Google Docs is compromised. Every confidential email you sent through Gmail is compromised. Every sensitive file you stored in Dropbox or iCloud is compromised. The American Bar Association addressed cloud computing back in 2017 and said lawyers can use it without giving up privilege, as long as they take reasonable security steps. And bar authorities in New York, California, and other states came to the same conclusion. The entire profession has relied on that understanding for more than 10 years. The ruling ignored all of it, and that is what makes it dangerous. Not because the reasoning is sound, because the ruling is getting attention. The right answer here is simple. Using an AI tool to optimize information is not the same as telling a person your secrets. AI is infrastructure. It is not someone sitting across the table from you. Courts need to shut this reasoning down before it bleeds into every cloud-based tool that we all rely on. Now, if this changed how you think about AI and legal privilege, hit that like button and subscribe to this channel, and send this video to anyone who has ever typed a legal question into a chatbot, because they probably have no idea that this risk exists. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.